I believe the Supreme Court left a huge carve out, a good one, in their injunction decision, but no one's talking about it because it's in a footnote. This is the explain like I'm 5 version. If you want the full, more detailed version where I go through the footnote and Kavanaugh's mentions, it's a couple videos back. I'm wearing a yellow t-shirt. Essentially what the Supreme Court determined was that a district court judge could not impose a preliminary nationwide injunction on the executive branch. In other words, a nationwide pause on a policy while the case plays out. More accurately, the Supreme Court said that a district judge cannot do that unless there's an explicit law allowing them to do so. So what some people immediately said was, well, Congress could just pass a law, but they're not going to do that. However, there are some laws already that grant that sort of power to a district court judge under specific circumstances. One that everyone is familiar with is the class action one. But there's another law that gives district courts certain authorities over the executive branch that is mentioned in a footnote by Amy Coney Barrett and several times by Kavanaugh in his concurring opinion. That law is called the Administrative Procedure Act, or the APA. What the APA does is it outlines judicial review for agency actions. Federal agencies are basically all the departments under the executive branch that are each tasked with managing a specific thing. So one, for example, is the Department of Homeland Security. NASA is another agency, the EPA, another agency. It doesn't have to have agency in the name. And what the APA says is that when an agency does something, whether it issues a rule or a policy, someone can sue, and a district court judge can, in fact, decide to set aside or not set aside that agency action. And Kavanaugh, in his concurring decision, repeatedly describes a functional equivalent to a nationwide injunction that would be a preliminary setting aside of an agency action under the APA. He essentially says that is still possible as long as it fits the APA requirements. And while the APA review requirements are a little strict for some things, they also include just if something is illegal or unconstitutional. And to be clear, the APA explicitly says it cannot be used against the president or Congress, but it can be used for the agencies. When a president signs an executive order, they're not the one that's typically carrying out or enforcing it. The agencies are. For example, if he signs an executive order saying that a child born in America but to an undocumented parent is not a citizen, yes, we understand it's unconstitutional, but until that's determined, the executive order is essentially instructions for the agencies to carry out. They have to issue internal policy or rules on how they're going to carry it out. For example, not issuing passports or beginning the deportation process, and those agency actions can be reviewed by a district court judge. And according to Kavanaugh, a preliminary setting aside of the agency action is still possible, which basically means that while a district court judge cannot impose a nationwide preliminary injunction against the executive branch as a whole or the president, it can issue the functional equivalent, basically the same thing in practice, against the agencies. Does that make sense? I hope so.